I would like to give over to Rachael Macauley, who is moderating the conversation with our second special guest, which is Thandeka Chauke. Rachael, over to you as you are having your scribers, Farida and Ignace. Over to you, Rachael.
Yeah, thanks very much. So hi everyone, my name's Rachael Macauley. I've been interning with AIHLI Legacy for the past 3 months, working on this undocumented campaign and putting the conference together. So I'm really happy that we're going ahead today. I'm currently undertaking my master's at the University of Stirling in Human Rights and Diplomacy, alongside Arno, who's also interning with AIHLI Legacy as well. So our scribers today, as Ntombi mentioned, is Ignace and Farida. They're both third-year undergraduate students in the Communication for Development at the Pan-African Institute for Media, Information and Communication Studies. Ignace is a presenter and a reporter for Denny Voice, a web TV channel dedicated to children and youth. And he also holds the position of Communications Officer in the Students' Club in Communication and Journalism, as well as being a young researcher for the Sahel and Gori Institute and Save the Children. And Farida is also a presenter at Denny Voice, where she hosts programmes focusing on the rights of children and youth, addressing essential topics for their wellbeing and future. As well, she also serves as the Secretary General of the Communication and Journalism Students' Club, contributing to the growth and development of her peers. She's also passionate about social justice issues, and she aims to use communication to promote human rights and the development of future genes. So we'll be hearing from them a little bit later on as well. So to introduce our speaker today on statelessness, we have Thandeka Chauke. I'm very honoured to introduce her. She's a human rights lawyer, social justice advocate and Afrofeminist focused on nationality rights, refugee and migrant rights, sexual and reproductive health rights and socio-economic rights. She leads the Statelessness Unit at Lawyers for Human Rights in South Africa. She oversees the Law Clinic and spearheads efforts in strategic litigation, advocacy, research and capacity building to combat statelessness. Thandeka also administers the Southern African Nationality Network and edits the Statelessness in Southern Africa newsletter published by SANN and the UNHCR Regional Bureau. Additionally, she also serves as the advocacy lead in the global movement against statelessness, and she holds a bachelor's in economics and law from Rhodes University and a master's of science in international human rights law from Oxford University. So here we are. Here's Thandeka presenting on statelessness. Please take it away. Thanks.
Thank you, Rachael. Can you see my presentation?
Yeah, looks good.
Yes.
Thank you. Perfect. And thanks once again to you and our participants for today for joining this very important discussion. So Lawyers for Human Rights, which is the organization I work with, is a nonprofit human rights organization that focuses on various thematic human rights, one of those being statelessness. And we work to address gaps in citizenship or access to citizenship-related documentation through direct legal assistance, which we provide in our law clinics, as well as strategic litigation and various advocacy and research initiatives. But today I'll be talking more broadly about statelessness as it affects Africa, and in relation to kind of recent developments in the legal sphere in relation to protecting the right to nationality and working towards the eradication of statelessness in the continent. Some of the points I will relate to the South African context as well, so that we have a more tangible kind of domestic example of how statelessness manifests and why we believe that some of these exciting developments in terms of legal frameworks offer us potential solutions to addressing this critical human rights issue for once and for all. So today is International Human Rights Day, in case no one knew. And it marks the anniversary of the adoption of the Universal Declaration of Human Rights in 1948. One of the key provisions in this declaration is Article 15, which proclaims that everyone has a right to a nationality and the right not to be arbitrarily deprived of this right. However, for millions of stateless people worldwide, the promise of this right to a nationality and the notion of universal human rights in general remains out of reach. And statelessness is one of those stark reminders of the gaps that we must still work to bridge to ensure that no one is left behind in the fight for equality and dignity. And I believe the theme of this year's International Human Rights Day focuses or centralizes this aspect of equality. Now, to understand statelessness, it's important to first understand the idea of nationality/citizenship. And I will be using these terms synonymously throughout this presentation, although it's important to note that depending on context, nationality and citizenship can mean very different things. However, in the context of international human rights law, you will see the term nationality used in the language of treaties or in relation to states and how they interact with each other on the aspect of nationality. And then you'll see the term citizenship being used more on a domestic or local level. Nationality itself is a human right. I think that's important to underscore. It's not a favor that a state must grant to people residing in its territory. It is a human right. And it basically describes the formal link or connection an individual has with their state. And this link or connection then gives rise to specific rights and responsibilities. So, for instance, the right to go to school, the right to work, the right to vote, or to even run for public office, and responsibilities around then fulfilling obligations to be loyal to that state. Statelessness then is the inverse or the direct opposite of having a nationality or citizenship, and it has been described as the most acute violation of the right to a nationality. And essentially, a stateless person is someone who lacks this formal link or connection to the state. And we say formal relating to the legal link. So factually, you might have a link related to birth on the territory or birth to a citizen, but perhaps in practice, you've been denied nationality. So the description of someone who is stateless entails both looking at the law of the country that is denying them or depriving them of citizenship, but also how that law is implemented in practice. Statelessness in the African context stems from multiple factors, complex and interrelated factors, such as the lack of birth registration. So without birth certificates, you'll find that many children struggle to then be able to claim nationality, since the birth certificate records two important facts that they would need: where they were born and who their parents are. The lack of legal safeguards or gaps or conflict in citizenship laws between states is also a key contributor. Some of the common legal safeguards that we see missing in domestic citizenship laws relate, for instance, to cases of children who have been abandoned without any, adequate information regarding where they were born or who their parents are, which makes it difficult for states to then determine their citizenship and therefore to issue an accurate birth certificate. You also find that lack of measures to prevent statelessness in the context of state succession also contributes to statelessness. And state succession basically refers to when the borders or the territory of a particular state change for whatever reason. So historically, this is relevant in the context or the legacy of colonization in Africa. But we also see more contemporary forms of state succession where there's still ongoing disputes around determination of borders, again linked to colonization. But so, for instance, if we look at Sudan and South Sudan as one of the recent examples, ongoing issues between Eritrea and Ethiopia, and then also other ongoing issues around the Bakassi Peninsula, which is now issues between Nigeria and Cameroon, and being able to determine who's Nigerian and Cameroonian. In the South African context, you could also think of the establishment of the TBVC states back in the 50s or 60s, leading up to the 1990s. And this is a time when thousands of Black South Africans were stripped of their citizenship and then relegated to the citizenship of the Transkei, Bophuthatswana, Venda, and Ciskei states. And in an effort to then reconsolidate these homelands into South Africa, in the aftermath of 1994, there was an effort to adopt a Restoration of Citizenship Act. But obviously, there are still some people who might have fallen through the gaps in terms of being able to reestablish their ties and claim to South African citizenship. Another key contributor is generally around lack of due process that we see in African states. And this manifests through inordinate delays in terms of being able to access nationality documentation. So for instance, to access birth certificate or IDs in a timely manner then impacts or increases someone's risk to becoming stateless. The denial, or the arbitrary denial rather, of citizenship or access to citizenship related documents can also result in statelessness. And then we've also seen many cases of deprivation of nationality or nationality documents. And this here speaks to a phrase you might have come across when reading up on issues of statelessness, the fact that some are born stateless and others become stateless. So we're seeing both statelessness that manifests at birth, where children are inheriting statelessness or can't find pathways to nationality due to the citizenship laws of the countries that they're born in or linked to, or people who initially had citizenship but are now have been stripped of that citizenship, either through law or through practice. A common example in the South African context is the ongoing issue of ID blocking, where people are having their identity documents invalidated, often on the basis or suspicion that they are not South African and therefore not entitled to have those documents in the first place. But the lack of due process there often then leads to statelessness because there aren't avenues to receive reasons for that decision or even to challenge it. But at the root of the issue of statelessness, really, and if there's one thing to be taken from this presentation, is that statelessness is caused ultimately by discrimination. So even when you look at these causes that I've just highlighted, at the root of each one of those is discrimination. Discrimination based on gender, discrimination based on race and ethnicity, discrimination that is based on class or socioeconomic status, discrimination based on religion, based on disability, or even based on sexual orientation, gender identity or expression, or even sex characteristics. In South Africa, in addition to all these issues, we see that the challenges that create and entrench statelessness amongst affected people are then compounded by a history of structural inequalities and injustices, so now relating specifically to the legacy of apartheid and how that continues to impact on the ability of people to secure South African citizenship or documentation. It is also compounded by a culture of entrenched gender inequality, given that gender discrimination is again one of those root or main contributors to statelessness, as well as systemic administrative inefficiencies that continue to perpetuate exclusion. And these are once again linked to this aspect of delay, denial, and deprivation. In terms of the consequences of being stateless, the effects of it are devastating. If anyone has had the unfortunate experience of actually living as a stateless person, I'm sure you would relate to this. Stateless people face numerous barriers in accessing basic rights like education, healthcare, or social assistance, or any other rights that are enumerated in the Universal Declaration of Human Rights. It makes them particularly susceptible to abuse and exploitation. So we've just listened to the challenges around human trafficking, smuggling, and that kind of thing. When you have someone who is undocumented and under the radar, this makes them more vulnerable to such practices, especially now if they are children on the move who have been trafficked and are moving across borders without any form of identification that tells us who they are, where they are coming from, so that we could reunite them with their family, if that is a consideration, and even how old they are, because sometimes age determination is also directly linked to the kind of protection that a child can get. And then one thing that is often not spoken about in terms of the consequences or the impact of statelessness is the psychosocial consequences. And we have seen through our law clinics and working with people who are stateless, the psychological toll that it takes on them. Many of them grapple with feelings of alienation, a pervasive sense of not belonging, suicidal ideation, even in some severe cases, and constant uncertainty about the future for themselves, but also for their family. So it's not just an individual dilemma. It's very much a dilemma that impacts the family and even society on a broader level. Highlighting the harsh realities of these consequences, in 1958, Chief Justice Warren of the US Supreme Court described statelessness as a form of punishment more primitive than torture. And so that's one thing to kind of reflect on when you think of the issue of statelessness and why human rights activists are pushing for an urgent resolution to the issue. We want to underscore the fact that while this aspect of statelessness does sound like, like a legal anomaly or something that is so abstract and distant from us, it's in fact something that is more common than you think. You've probably come across a stateless person once in your life. You've either been stateless yourself or been placed at a risk of statelessness due to some of these oppressive systems that I've noted. But what is key to underscore is that statelessness is a human-made problem, because it is states who get to determine who belongs and who doesn't belong. It is states who write the laws to this effect. And it is states who, when statelessness has been resolved, have taken either decisions, special measures to accommodate stateless communities, or even decisions to address issues of delay, denial, or deprivation at local office level. It's often a state official who simply signs off on a birth certificate or a certificate of nationality, and that brings an end to this kind of horror. So it's important to underscore that statelessness is resolvable, but it's also preventable. And there does exist a robust and comprehensive legal framework protecting the right to a nationality and promoting the prevention of statelessness at both the international and regional level. However, what we've seen is that the numbers of stateless people globally continues to grow at the domestic level due to persisting gaps in legal frameworks, or I think more commonly, poor implementation of existing frameworks. And this is very true in the South African context, where we now have the right to citizenship protected in the Constitution. But what is on paper doesn't necessarily translate to what is on practice, as we have also seen a number of cases where people have still been denied or deprived of their citizenship, despite it being a constitutionally protected right. In terms of the international context, the right to nationality and issues of statelessness are provided for under two main UN conventions. And this is the 1954 Convention on the Status of Stateless Persons. And this one is important because it provides the definition of who a stateless person is. It requires states to then adopt some sort of statelessness determination mechanism to be able to identify stateless people. And then it establishes protections and minimum standards for those who have been then accordingly identified as stateless to ensure their dignity. However, the 1954 Convention doesn't fully provide for the specific measures that states can then take to resolve situations of statelessness. This is only done then or elaborated on in a second convention that followed almost 6 or 5 years later, being the 1961 Convention on the Reduction and Prevention of Statelessness. And it aims to reduce and prevent statelessness as per the title, and to secure the right to nationality for everyone, including children, by proposing specific legal safeguards that states can incorporate into their citizenship laws. And these are safeguards that speak, for instance, to the case I mentioned of a child who may have been adopted and found without adequate information as to their parents or their place of birth. Children who are, for instance, born in transit, so maybe on a train or on a plane. How do we deal with those cases? It deals with the aspect of state succession, also realizing that changes in borders and the history of colonization is a key contributor to some situations of statelessness that we see globally today. However, the challenge with these two conventions in the African context is that they are very prescribed. So they enjoy very low ratification rates, which means their impact is in fact limited, and so is their credibility in the African context. But recently, however, the African Union on 18 February of this year adopted the protocol to the African Charter on Human and People's Rights, which now relates to the specific aspects of the right to a nationality and the eradication of statelessness in Africa. And this protocol is the result of a collective effort by the African Union, the African Commission, the African Committee of Experts on the Rights and Welfare of the Child, African civil society organizations, and other critical stakeholders, including the UNHCR. And what it does is that it seeks to fill the gap left by the African Charter on Human and People's Rights in respect to the right to a nationality. Now, if you're familiar with the African Charter, if you look through the charter itself, you'd note that there is no specific right to citizenship or right to a nationality. However, the African Commission and the African Court have been relying on invoking Article 5, which speaks to the right to dignity and legal status in cases dealing with nationality and citizenship rights. And a lot of these cases initially were around a political context where there were many incidences of citizenship stripping. For instance, in Botswana with the Modise case, where John Modise, running against the political opposition, was stripped of his Botswana citizenship, arbitrarily deported to South Africa on a claim that he was in fact South African, but for many years then lived this life of being deported between the two countries. In South Africa, he didn't have documentation. In Botswana, they had stripped him of his citizenship and his documentation, and he ended up living in a no man's land. Following that was an issue in Zambia with Kenneth Kaunda, and you also see examples in Northern Africa and Cote d'Ivoire with issues around the introduction of the concept of ivoirité that in fact contributed to civil unrest in the country, and hence speaking directly to the need to address issues of citizenship, belonging, and nationality in the African context, as it directly contributes to peace and security. The first draft text of this treaty was prepared following the adoption of two resolutions. So the first of those was in 2013, Resolution 234, which explicitly affirmed that the right to a nationality is implied under the right to dignity and legal status. As I mentioned, the African Charter itself didn't include an explicit right, but the African Court and Commission had been reading in the right to dignity as a critical right that is interlinked and related to nationality. This resolution also assigned the task of carrying out an in-depth study on issues relating to nationality in the African context, and this was a task assigned to the Special Rapporteur on refugees, asylum seekers, migrants, and internally displaced persons in Africa. And following this activity in 2013 and 2014, the African Commission adopted Resolution 277, where the findings and recommendations from the study were then launched, and a new task was assigned to the Special Rapporteur to begin the drafting of the protocol to the African Charter on the right to a nationality. So all in all, this protocol aims to facilitate the belonging and inclusion of all Africans by providing legal and practical solutions to statelessness and identifying the principles that should govern relations between individuals and African states in relation to these issues. The protocol also takes into account the particularities of the continent. Notably, it takes into account the history of colonization and apartheid and how this has shaped the experience of statelessness on the continent. It addresses issues around recurrent and protracted conflicts that are based on identity and have historically resulted in mass expulsions in some parts of the continent, as well as forced displacement. It addresses also the aspect of citizenship stripping, in both in the political context and also through emerging practices that we see in certain states where people's nationality-related documentation is being confiscated, destroyed, or invalidated without due process. And so I'm just going to run through 10 facts of the protocol just to kind of highlight where it contributes to strengthening the legal framework and how it offers the potential to transform our notions of belonging, of dignity, and of citizenship in the African context. I would like to also underline its ambitions that you will see if you read the preamble to promote a united African citizenship. So the first fact is that the protocol affirms that everyone has a right to a nationality. And once again, just to reiterate that the purpose of this is to explicitly now cover that gap that was left in the African Charter where the right to a nationality was excluded. Interestingly enough, when the African Charter was first drafted, it did include the right to a nationality. However, by the time it was finally adopted in 1981, this provision had been deleted. And unfortunately, because there are no travaux préparatoires to the African Charter, it has been unclear why, through debates and negotiations, there was a decision to ultimately exclude the right to a citizenship or nationality. However, this protocol now also underscores that nationality is a cornerstone for legal identity, for human dignity, and access to all other fundamental human rights. So now it's re-centralizing the right to citizenship as a human right and as a right that unlocks access to other rights. And this ties in with Hannah Arendt's comment about the right to citizenship, describing it as the right to have rights. Secondly, it promotes interstate cooperation as well as collaboration with international and regional agencies. And this is critically important in the context of statelessness, which really has to do with borders. And so there will be a need for collaboration between states. And what the protocol urges states to do is to work both individually and collectively to prevent and ultimately end statelessness in Africa. One key distinction of the protocol from the UN conventions is that it emphasizes the eradication of statelessness, while the other two, even when you look at the title, the first is focused on the status of stateless persons, so the identification and protection of stateless persons, and the second is focused on reduction and prevention. But neither of them speak specifically to eradication, which this new protocol does. And again, as I mentioned, it highlights the importance of nationality to nation building and to peace and stability on the continent. And this is important beyond the aspect of human rights. The third important thing that the protocol does is that it promotes gender equality nationality laws by mandating states to guarantee equal rights for men and women in all nationality-related matters, including the ability to pass on nationality to a spouse or child. And now this is important because it addresses the fact that statelessness is also a profoundly gendered issue. Yes, it impacts everyone in a significant manner, but no one speaks about the fact that its impact on women is unequal. So women are disproportionately affected by legal, administrative, and systemic barriers in terms of being able to secure citizenship for themselves and also their children. And you see this directly through laws that bar women from being able to acquire, change, or keep their nationality when they get married. And then also laws that prevent women from being able to pass on nationality to their children. And globally, there are approximately 50 states that limit women's rights to acquire, change, or retain nationality. But particularly problematic are the 24 that continue to deny women the right to confer nationality on their children, 7 of these being African states. So in Burundi, in Eswatini, in Libya, in Mauritania, Somalia, Sudan, and Togo, we continue to see laws that are problematic in this regard. These laws are based on the antiquated principle of dependent nationality or unity of nationality of family. And this is a deeply patriarchal idea, which is informed by the notion that a family should have the same nationality. And this nationality should, let's say, naturally be determined by the man, who is often perceived as the head of the family. And this, of course, has 2 implications. So firstly, women are then forced to renounce their nationality and assume the nationality of a spouse when they get married. However, they are not protected from statelessness in cases of divorce or widowhood. Secondly, when women are barred from passing nationality to their children due to this bias towards patrilineal descent, it heightens the risk of statelessness for children where the fathers are unknown, unable to facilitate access to citizenship, either because they are stateless themselves or perhaps they've been forcibly separated from the family, or maybe the fathers are unwilling to register the child, so perhaps they have abandoned the family or have refused to even acknowledge paternity. And this is also important in the South African context, where part of the population includes a number of migrants or asylum seekers. And often we have seen cases where there are mixed nationality parents. So for instance, the mother is from Eswatini and the father is South African. You will have Home Affairs officials insisting that the child then pursue citizenship in Eswatini or to pursue Swazi citizenship, but are unaware of the fact that, the Swazi constitution and the citizenship laws actually prevent Swati women from being able to do so. And again, this underscores one of the causes I mentioned around when you see gaps or conflicts between two states and their nationality laws, and how that can contribute to statelessness when there is no harmonization. And the CEDAW committee, which focuses on implementation of the Convention of Elimination of All Forms of Discrimination Against Women, has highlighted an important fact. The fact that even when a state has gender-neutral laws, there might still be indirect gender discrimination contributing to statelessness and exclusion. And there has been some ongoing recent research on this aspect in the Dominican Republic by Alison Petrozziolo, where she looks at birth registration as a bordering practice and the ongoing discrimination that is faced by Dominicans of Haitian descent, and particularly the women, in terms of accessing citizenship for themselves and their children. And some of the gender-specific barriers she highlights in that context are around denial of proof of birth forms at hospitals, demands for extra-legal requirements for both parents to appear at birth registration, which obviously prejudices single mothers, and the imposition of financial penalties for late registration. And these practices contribute to the intergenerational perpetuation of statelessness, where unresolved statelessness in one generation often leads to inherited statelessness in the next. And I'm sure we've all seen or observed similar practices in the African context. In South Africa, for instance, you may have come across the Naki case, and this is the case of Center for Child Law versus Minister of Home Affairs, where LHR represented CCL to challenge a particular provision in the birth registration laws and regulations that prevented unmarried fathers from being able to register their children in the absence of the mother. And this principle was in fact linked once again to a very patriarchal idea of the maternal preference rule. So the idea that it is the mothers who are always responsible for the children, and it is the mothers who will therefore always show up for registration. But this is to the exclusion of the fact that not all families are binary, and not all children are living in the care of their parents. And some fathers are indeed very present primary caregivers when it comes to their children. And so this was declared unconstitutional. However, new challenges arose as the Department of Home Affairs began requiring DNA proof of paternity from the fathers. And when you look at the circular in which they introduced this requirement for DNA, it speaks directly to this idea of people trying to invade the nation through the womb. Once again, very patriarchal ideas around citizenship and how we regulate it, because it says that the rationale is that we see a lot of South African women apparently who are marrying or having children with non-South African men, and then using these children to establish a right to remain, to reside, or to access a pathway to citizenship through the children. It's a very strange concept, but as you can see from that, that's directly rooted in discrimination and misconceptions around the idea of family. Moreover, we're also seeing practices of hospitals that have started withholding birth records or proof of birth forms from migrant women against the payment of maternity fees or due to lack of documentation. So once again, we see this example where the ConCourt has outright said this is unconstitutional, but in practice, we continue to see ways in which women and their children are being denied access to citizenship and documentation. The other important thing to underscore about gender inequality and nationality laws is that, as I mentioned, it has intergenerational consequences, but it's also intersectional. And what this protocol does is that it recognizes that various forms of social stratification, so whether it's gender, race, ethnicity, religion, class, socioeconomic status, disability, and others, do not operate in isolation, but they interact on multiple and simultaneous levels to contribute to systematic injustice and social inequality and varied experiences of statelessness. The protocol also includes important safeguards against statelessness during state succession by requiring careful handling of nationality-related matters whenever there's a change in borders. And to prevent statelessness, the ultimate rule is that an individual must retain nationality rights in either the predecessor state or the successor state. However states do this, is up to them, but this must be the core principle. So whether it's through agreements between the two states, 2 or 3 states, or if it's through harmonizing how your birth registration and citizenship laws work as you establish the new state. And this is very critical, again, in the African context, as I mentioned, how colonization continues to impact on how we see statelessness today, but also it's pertinent for those specific regions in Africa where colonial borders continue not to align with the ethnic and cultural composition of the border populations living there. So I've already mentioned South Sudan as an example, but there's also, let me actually unpack that as an example. So for instance, when Sudan amended its nationality laws following the secession, it automatically stripped Sudanese nationality from those that it presumed to be South Sudanese. And again, seeing the intersectional link, you can see how this is ethnically motivated. And this left many, especially those who are of mixed heritage or those residing in border regions like the Nubas, in a precarious state of indeterminacy without clear legal status. It actually resulted in a case that went to the African Committee of Experts on the Right to a Child called Benjamin versus Sudan, if you'd like to read more about that. In this context, conflict and forced displacement can further complicate situations of statelessness and state succession. And these are the challenges that we see now with the Banyamulenge in DRC, who are still fighting for citizenship or recognition. And they originally hail from Rwanda and Burundi and often struggle to obtain birth certificates for their children. So it's a very multi-layered issue. As I mentioned, it emphasizes equal nationality for rights for all. We've already looked at the gender discrimination provision, but it also has a broader discrimination provision, which is important. The racial and ethnic discrimination aspect speaks directly to the fact that over 75% of the world's stateless population belongs to racial, ethnic, religious, or linguistic minorities. And this obviously indicates a widespread systemic issue that is rooted in laws, policies, and practices that are designed to structurally exclude. Some notable examples or more common examples of racial exclusion or ethnic exclusion can be, for instance, the Rohingya in Myanmar, the Syrian Kurds, the Roma, the Palestinians, the Lhotshampa of Bhutan, and Russian minorities in Estonia and Latvia. However, in Africa, you also find this in Cote d'Ivoire, where nearly 700,000 stateless people, primarily from the Diola community, currently reside. And then you'll find other affected groups like the Tuaregs, which are nomadic in Northern Africa or Algeria. As I mentioned, the Banyamulenge in DRC, the Maragoli in Uganda, and the Nubians in Kenya. In the South African context, you can think of this discrimination provision in terms of the institutionalized xenophobia and Afrophobia we now see impacting on officials' ideas of who is entitled to citizenship, who is entitled to citizenship-related documentation, and also the type of documents that they're entitled to, because issues of documentation carry with them a lot of stigma, despite the fact that statelessness, in fact, affects majority of people who are unrecognized South African citizens. Added to this is the aspect of digitization. I think this has to be one of those emerging concerns we should be aware of, and the potential for racial profiling or discrimination that is designed or built into the technologies that are being adopted across the continent to, improve the efficiency of birth registration and access to identity documentation through digital ID. Religious discrimination. So, for instance, in countries where Muslim-looking people with Muslim-sounding names face discrimination. Again, the Diola in Cote d'Ivoire is an example. But also in countries like Algeria, Egypt, and Morocco, then you see the inverse, where people who are non-Muslim or non-Arab are then targeted. Another key thing would be discrimination based on sexual orientation and gender identity, which has to be explored given the heightened risk of members of the LGBTI community being undocumented or stateless due to fear of approaching authorities or inability or gaps in the law in respect to the ability to pass on citizenship to a spouse or children. And there was a recent case in this regard in Namibia concerning 2 gay fathers who had children through a surrogate in South Africa, and complications arose there in terms of securing Namibian citizenship for them and even their birth certificates. Disability is something that has not been spoken about much, but equally critical in terms of impacting on statelessness, and the idea that children or persons with disability may have physical barriers in terms of accessing registration offices, but also social barriers in terms of fear of societal prejudice and stigma, where their parents might be afraid to even bring them to offices. Or in terms of processing applications, so those with cognitive disabilities and the ability to apply for citizenship in certain contexts. The protocol prioritizes children's rights, and it emphasizes that in all matters to do with the child's nationality, states must respect the best interests of the child. The African Committee of Experts has gone on further to say that statelessness is the antithesis to the best interests of the child. And so there can never be a situation where states decide that in whatever context, it is in the best interests of the child or children implicated to render them stateless or to leave them stateless. So it underscores the fact that states must find solutions to statelessness when it comes to children, and must also allow or facilitate for their participation in all administrative, judicial, or legal proceedings to do with their nationality. And this complements a general comment that's been adopted by the African Committee of Experts on the Rights and Welfare of the Child. And then it also includes crucial safeguards against a child with statelessness. So it builds upon the safeguards that I highlighted in the 1961 UN Convention, but it adds more emphasis within the African context so that it's more relatable to the situation of children who are stateless in Africa. And then it emphasizes the right to birth registration and links birth registration to nationality, that once the child has been registered, they should secure nationality immediately at birth or shortly after birth. It provides special protection for nomadic and cross-border communities. And in this provision, this is where you see a very intentional decolonial approach to law and policy making when it comes to citizenship that departs from more the generic approach taken by the UN conventions. So it looks at the specific situation of people who live at the border, people who are nomadic, and what happens when their citizenship is disputed, or when they don't have documents to prove citizenship, or when they have children while they're on the move. And it promotes the aspect of appropriate connection. So it says we must look beyond these two principles that we've been following for citizenship or nationality rights. One of those being jus sanguinis, so basing citizenship only on the right of blood or birth to a citizen, or jus soli, which is granting citizenship based on a link to the territory, so birth in a city, in the country, which applies in USA, but there are now ongoing discussions under the Trump administration to do away with that kind of birthright citizenship, which is concerning, but that's just a tangent. However, what it does is that it says, let's look at appropriate connection. Let's also look at place of marriage. Let's look at presence of family, repeated residence in a particular area, the location of burial sites, of grazing sites, where these communities or individuals are cultivating their crops, taking testimonies from community members, because often you'd find that they don't have any documentary proof that tells you where they were born, who they are, and you have to build that evidence through affidavits, for instance, or oral testimony. And then also looking at contribution to the state. It also considers aspects around kafala, so once again recognizing customary forms of adoption or customary practices that have been overlooked by conventional treaties or citizenship laws. It necessitates the recognition and protection of stateless persons, speaking directly to the 1951 Convention, UN Convention, by requiring states to establish criteria for granting statelessness status and to ensure stateless people can exercise universal human rights, access humanitarian aid, receive documentation, and enjoy protection against arbitrary expulsion from the state territory. And this speaks directly to the fact that while we know, or while there are indicators of the prevalence of a significant population of people affected by statelessness in Africa. So for instance, looking at the World Bank statistics of, I think there's nearly 1 billion people on the continent without legal identity. There is no confirmed number of people who are in fact stateless, because many African states, in fact, all of them, have not yet created a mechanism through which we can officially identify someone as stateless. So think, for example, as a parallel to the refugee status determination processes that exist in various African states, there isn't an equivalent for that in the statelessness in the statelessness context, which leaves many people unprotected and also vulnerable to arrest and detention because they have no document that actually explains their situation. And lastly, it includes comprehensive due process and administrative justice protections. So underscoring the right to be informed of any decisions regarding your nationality documentation or your nationality, the right to be given full reasons for any decision to be taken in regards to your nationality, specifically if it's to do with withdrawal or deprivation of that nationality, and the right to be able to challenge those decisions either through a judicial or administrative review. And this again underscores, if you've read through some of the jurisprudence emanating from the African Court and the African Commission on Citizenship and Citizenship Stripping, all of those cases had to do with the lack of due process when people were stripped of their citizenship arbitrarily, rendered stateless, and subjected to various forms of torture, of harassment, and generally the indignity of not being recognized as someone who belongs to that particular community or society. Now, for it to come into effect, it needs at least 15 ratifications from African Union member states. And in order to fulfill this vision of ending statelessness and fostering this idea, this beautiful Pan-Africanist idea of a united African citizenship, we are therefore urging all African states to promptly ratify, domesticate, and implement this treaty. It is a significant step forward, and it promises more progress in terms of reducing and enhancing the lives of the millions of Africans who are suffering this indignity of being stateless. And yeah, so it is only through these concerted efforts that this vision of an Africa where everyone belongs can be realized. And this brings me to the end of my presentation. Over to you, Rachel.
That's great. Thanks so much. It's really interesting hearing you go into a deeper dive there about statelessness. I know to everyone else, we did have a conversation on the For Humanity podcast, which is on YouTube. But yeah, I am just super interested in knowing a bit more of the case studies and everything that you went through. And thanks very much for all your input. So I just want to open it up to everyone else. Does anyone have a question or any comments or thoughts on what we've just heard at all?
Yes. I just can't show my hand. Apologies for that. Hi, Thandeka. My question is related to, are people, like from a South African perspective, that have their identity documents blocked? What is the vulnerability in terms of that for them? And what are the due processes that they need to follow? And is it as simple as going to Home Affairs and making application? Or is it more complex and they need interventions like from Lawyers for Human Rights in getting such matters resolved? Thank you.
Thanks for that. So with this issue of ID blocking, if one really wants to understand issues around documentation and citizenship in South Africa, it would be key to actually read that judgment. It was handed down on 16 January of this year, and we are still busy working on its implementation. So that's also one key contributor that we see to these persisting issues, is working with a state organ or department that refuses to engage or work collaboratively, which is something that this protocol encourages. But with where we currently stand with the implementation of the judgment is that the Department of Home Affairs was firstly ordered to deal with the lists of blocked IDs that have been compiled by Lawyers for Human Rights and LegalWise. Our list included, I think, at least 142 individuals. However, there is an acknowledgement by the department that a broader sect of the population is impacted, and this is close to 700,000 people. And the department was given until March of 2025 to deal with this balance of the 700,000 cases. And what it has to do in each of those cases where the ID has been blocked without regular processes or due process is that they have to immediately unblock the ID. Or if they deem that the IDs or some of them have been identified as a security risk, so for instance, if the blocked ID belongs to someone like, let's say, Thabo Bester, who's obviously a security risk, then the Home Affairs has the right to approach a court and get a court order to have that ID kept blocked. In terms of what people are supposed to do now, the department had also published a notice a few months ago threatening to cancel all blocked IDs. And of course, that then thwarts or undermines this court order from January 2024. And it is something that we have brought to the attention of the court. And we are currently negotiating with the department in terms of withdrawing or canceling that notice. We had, in fact, launched an urgent application to challenge the validity of that notice for various reasons, including the fact that it obviously undermines then the process that the court had initiated through the Mazibuko court order. However, if someone still has challenges with their blocked IDs, AIHLI has created various self-help materials that are available on our website, which I will type here, around how to get your ID unblocked. And this is advice around some of the useful documentation that you should compile. And then you approach your nearest Home Affairs office to begin that process. And of course, if along the way you encounter further legal issues, there are organizations like Lawyers for Human Rights and LegalWise and probono.org or LRC, Legal Resources Center, who might be able to provide pro bono legal assistance, and the Center for Child Law in relation to cases impacting children. So where children's birth certificates or IDs have also been blocked or denied on the basis that the parent has a blocked ID. I hope that answers the question. I will post the specific Know Your Rights materials in the chat box if anyone might find that useful.
Oh, thank you. Thank you so much. I think it also leads me to a secondary question. Obviously, your presentation has been exceptionally well in dissecting the concept on itself and taking us back from the context of where it all began and to where we are standing. I think what I would like to know is beyond obviously blocked identifications, there are adults that remain without any form of identification, and these are South Africans. And it's also based on number of prospective circumstances, similar to whether after they were born, nobody registered them at birth, and they were then adopted and nobody really actually knows how old they are. And this fundamentally affects and impacts an individual because they don't have a sense of knowing of self and any reflections on that. As an adult, like you went through the minor, like you were a minor and you could get assistance in terms of the departments or some of the civil society organizations that fundamentally work on these issues. But now for adults that are currently not having any form of documentation, they don't even have that blocked ID. They are just really stateless. They are really just individuals that are South African nationals, some of them, or they don't even know. How do we fundamentally help those and advocate for them so that their voices can be heard and they can find remedies? The reason I ask this is because I have noted, obviously, the work that you guys are doing on the ground fundamentally in advocating for these aspects. But beyond that, we have seen that in terms of the cases that get recognition, it seems like it's one casing at a time in some instances. And so I think for our advocacy efforts are able to bring a group of individuals together and have that facilitated at once instead of just having it staged like person by person or case by case in this instance. So I think that is just my question. How do we advocate better and how do we participate in these efforts? Thank you.
That's a great question. In terms of how we advocate better, one key shift is that we need to start centering lived experiences and recognizing people with lived experience of statelessness as experts in the situation, in the issue, and in its potential solutions. And this is important because statelessness is often seen as an invisible issue, because the people who are impacted are afraid to be seen or to be made visible due to, common reprisals, so the fear of then being found by the authorities, arrested, detained, and potentially deported to a country that is foreign. And then another aspect leading to their invisibility are the common misconceptions and myths that currently exist around statelessness, and getting those with the power to make decisions about someone belonging or not, to understand those misconceptions, especially in the African context where we have such a deep sense of belonging and roots. So when someone says I'm stateless and they explain what a stateless person is, a lot of communities will tell you, no, you're not stateless because we know where you were born and we know your family. But not understanding that this is now linked to the state giving you official legal recognition. There are also common misconceptions that statelessness often affects foreigners. So it's more like an illegal immigration issue, or it's just people without documentation. And again, this is a misconception we need to address, because even especially in the South African context, as I mentioned, you find those many who are what we call stateless in situ. So stateless in the country they were born in, the country they've always lived in, and have never left the borders of this country. So you're stateless in your own country. And I think this aspect then makes states feel like there is no responsibility to deal with the issue because it's just foreigners, especially in the context of South Africa, where xenophobia is a big challenge. And then another misconception is that people who are stateless because of their own fault, simply because you must be a bad person who has done something to be stuck in this very horrible situation. And now I come back to improving our advocacy and why it's important to center lived experiences. It's important to center lived experiences because it brings visibility to the human cost of statelessness. If you're able to see and listen to the story of someone who is stateless, you begin to understand on a very human level why we say this is one of the most severe human rights violations and a critical issue that we need to address. It also involves stateless people in inputting to the solutions and making sure that those solutions are actually responsive to their problems. So a very key example might be looking at birth registration, for instance, and trying to figure out why it is that while the Constitution protects the right to birth registration and the birth registration laws on paper seemingly look inclusive, but we still have thousands of children that are going unregistered. The Pakamisa case on access to education, the DBE actually revealed that, I think it was 2019 in an affidavit, they had close to 1 million children who had no birth certificates enrolled in public schools, and close to 800 or 900,000 of those were in fact South African children. So it tells us that there's a key problem. But we are not simplifying the birth registration laws to enable those who are being left on the margins to be included. We're not looking at the specific scenarios where we see children being denied of birth certificates. So children with cognitive disabilities, do we have policies that accommodate them and their parents in terms of being able to reach registration officers? Do we have policies in relation to abandoned children? Yes, there's a provision for social workers to register them, but are social workers and home affairs officials capacitated enough to be able to then do a statelessness or nationality determination when it comes to an abandoned child? Often we see that those cases are left until the child ages out, they turn 18 and they have to leave the childcare system, or they just become deported to any random country because those measures haven't been put in place. And so I think that's one way we can change our approach to advocacy, just really highlighting this as a human rights issue and an issue that impacts people on a very personal level. I think also highlighting the cost to society. So who are these people that we are leaving stateless? When I look at some of my clients, these are young South Africans who have excelled in getting 80% in their matric examinations and becoming stuck at home because they can't proceed to further education or to get jobs. And these are people with really great potential to contribute to society in a meaningful way. And I think another key issue is to relate statelessness to the development agenda. So not just the human rights agenda, but it's important to development actors who advocate for, no one left behind, that principle. But if stateless people are unaccounted for, or unseen, then obviously we're leaving behind people. And I think lastly, just to underscore, I think my whole presentation talks about having stronger legal frameworks for protection and recognition. And one of those is signing onto this new protocol. I think that will be key to changing even our legal frameworks, our policy and practices as they relate to access to citizenship and documentation in the South African context.
Thank you.
No, that's great. Thanks so much. And I can see we've got a question from Andrew. Feel free to unmute yourself and ask away.
Thank you very much, Thandeka. I don't know whether you can hear me. I don't know whether I'm frozen or you can hear me.
Yeah.
You can hear me? All right. No, thank you very much. Ooh, yeah. There are a lot of problems, A lot of problems. There's two things that I want to bring to you. There's a case of some group of community that they've been living around the UN offices for some time. Can you hear me? Oh, okay. Am I audible, Rachel? Yeah, there's a group of community that was living around the UN offices. They were moved from central Pretoria, then they went to Brooklyn, and I interacted with them, and now they are being dumped somewhere. And I'm using the word dumped because just somewhere nowhere in between, in the Bronkhorstspruit, between Bronkhorstspruit and Witbank. Are you aware of that community? Because they're stateless as well. And if you're aware what is being done about that. And then also the education of South Africans, for example, on the problems that are there of stateless people. How are you educating them so that it should not be seen as like lawyers are just pushing this to make names for themselves? And I'm saying this with human rights lawyers and around amongst the people on the ground. There's a feeling that there are certain NGOs that are sponsored to destabilize the country by advocating for foreigners to disrupt the country. Because if you look at the case of Stelfontein mine, foreigners are the ones that are coming out from other countries. They are doing illegal activities, and now they have to be rescued. And the country spent millions. And someone that is sitting and struggling said, "But you have stopped to give us certain allowances, but you are spending the money on people that went on the ground, underground, illegally, so whether they were kidnapped." So how do we start educating our communities around these rights, around this condition that some of the people really are living in? And I feel that if we are able to educate the people, our people are accommodative, they are sympathetic and empathetic, and they can be able to work and support this. Thank you very much.
Thank you, Andrew. I think, the comment I made around common misconceptions and myths around stateless people is almost demonstrated in your question. So this first case of the people living outside the UNHCR buildings who were unfortunately evicted and removed to this farm area actually concerned refugees or asylum seekers in South Africa who were seeking to negotiate resettlement to another country due to their, claims of being unsafe and being unable to integrate in the South African context because of issues around xenophobia, access to documentation, and life simply becoming intolerable for them here in South Africa. And then the second case, again, speaks to mixed issues around ideas of illegality when it comes to documentation and understanding who is undocumented, who is an asylum seeker, and who is a stateless person. And there are overlaps in terms of this. But often when we see these new stories reported, and there's been an effort by us to also empower or capacitate journalists and how they report on statelessness and to do this ethically and accurately. But there is often, can I say, a carelessness around terminology being used. And this has built into these misconceptions that when you talk about statelessness, this is merely about illegal foreigners or undocumented people who have done something wrong, and therefore, there's no point in helping them. the fact is that often in those cases, there hasn't been a statelessness or nationality determination process. And this is why we have been advocating for South Africa to establish a formal mechanism for that reason, so that Home Affairs officials, DSD, so the social workers that work with abandoned or orphan children, and other stakeholders, maybe DBE, the teachers were able to identify documented children in schools, can then be trained in terms of how to do that identification, what rights people in those circumstances are entitled to, and most importantly, how to resolve such cases. And I think in terms of educating and awareness raising, advocacy and awareness raising, I've shared, for instance, one video that we created as part of the Unblock My ID, Unlock My Life campaign. And this campaign was run concurrently with the litigation. And its main purpose was then to bring awareness and sensitivity amongst the South African public as to what this ID blocking issue is about. Because we kept encountering comments where people thought that, Lawyers for Human Rights is simply fighting once again for illegal foreigners and refugees in South Africa to be able to access citizenship and documentation. But the purpose of us telling these stories is to get them to understand that it is South Africans, it is your own people, our own people who are going through these issues. And hence the problem is not necessarily with the person. It's not a refugee who is fleeing for their life. It's not an undocumented person who doesn't fit under the immigration or refugee regime in terms of documentation. It is also South Africans. And the problem is the Department of Home Affairs as an institution, and whether or not we can still term it a rights-based institution, or is its emphasis more on security? It does have the security role, but we often see that it has been functioning more and more on the basis of suspicion and not on service, and then denying even those with a clear entitlement to documentation and citizenship to that documentation and citizenship. However, there's also a risk and safety element attached to it whenever we ask our clients if they want to share their story or if we center them as part of our advocacy campaigns. Because even as you go through some of the content we've posted on our social media regarding the stories we've been told or trying to amplify the voices of those who are affected, they are still met with, viciousness, hostility, and harassment, even online. People insist that these are illegal people. And so I think it boils down to each one of us. This is a collective issue. Human rights in general, as someone mentioned, are a collective responsibility for all of us. And I just hope from this presentation that you advocate anywhere you go to say that human rights can be universal, but the notion of universality is challenged by the reality of the people who are not citizens and therefore who can't access these universal human rights. So advocacy even starts at an individual level. And I hope, Andrew, that, when you have dinner with family or, go to church over Christmas, whatever, you raise awareness wherever you are.
No, that was great. Very, very well said there. That was excellent. Is there any other questions or comments at all for Thandeka before we go on to our closing takeaways? You can pop them in the chat if you don't fancy talking.
Good evening, madam. This is Dr. Rangaswamy from India. Okay, so good evening from India. So far as India is concerned, like India has not ratified that 1951 convention, but despite we have extended, shelter to Tibetans and many other communities, they are, protected under that. The major reason given by government of India to not accepting that convention is like balancing this migration and refugee problem. So how do you pursue that migration and refugee problem, madam? Is it really a real reason for government of India to say that because of that we are not ratifying that 1951 convention, but despite on the basis of certain domestic policies, they have extended protection for some refugees. So my that question is like how to balance this immigration and refugee problem.
So maybe I can answer this generally to say, I think states that the two UN conventions on statelessness, just for a bit of context as to why they are so undersubscribed, they were actually drafted at the same time as the refugee conventions, because if you look at their dates, this is in the aftermath of World War II, when we actually began to see a lot of these cases around citizenship stripping, and hence Hannah Arendt's comment, she was impacted herself, was one stateless, of the right to have rights. And so it was once negotiated as one convention dealing with both international protection for refugees and then this issue of statelessness. But because statelessness speaks directly to matters of state sovereignty, so the right of states or to have exclusive discretion in determining who is a citizen or not, it became too contentious to adopt them at the same time. And so the refugee conventions went on first, and then later states came back to address the issue of citizenship after realizing that this problem is only growing, it's escalating, and it's not going anywhere. And part of the reason why it's so undersubscribed is there was like this concerted effort to push for ratification around the international protection issues for refugees, but the mandate for statelessness was only added to the UNHCR's agenda much later. So there was no UN agency actually responsible for pushing ratification of these two treaties. And now we see a lot of states actually use that argument to say, we already have an international protection or international legal protection framework that covers refugees and asylum seekers. Why do we need to sign more in relation to statelessness? Again, underscoring the point I made around these misconceptions, thinking that statelessness is only about refugees or migrants. Majority of the cases that we see are people who are stateless in their own countries. So no, the Refugee International Protection Legal Framework does not provide sufficient protection for stateless person. It's only stateless people who are also asylum seekers. So if you think of Palestinians, for instance, who might be covered by the Refugee Legal Protection Framework, but not those who are like majority of our clients who are blocked IDs. I was born here in South Africa, registered as South African, used this ID, voted in various elections. Now suddenly I'm told I'm not South African. You can't claim asylum status as a stateless person because which state are you fleeing from? And which state are you looking to protect you when none of them formally recognize you? And so I think that's one key issue, is addressing those misconceptions to ensure that our responses or state responses to statelessness are in fact appropriate to the situation. And a part of that includes lobbying or even raising awareness among state actors that there is indeed a difference. And this is why you have civil society actors and UN agencies, regional agencies pushing for ratification of international frameworks that can harmonize how laws work between states, but also ensure that we've included specific safeguards in our citizenship laws.
Thank you. Thank you, Thandeka.
That's great. Thanks very much. Do we have any other final questions or comments at all before I pass over to Ntombi? Amazing. Well, thanks very much, Thandeka. That was super interesting and great having you on.
Thank
Ntombi,
you. Thanks, everyone.
Thank you.
Oh, thank you very much, Thandeka. I think the conversation, including the presentation, was very informative, and it has enlightened us in terms of the other areas and avenues that we still need to work on. As you said, rightfully, it is a collective effort, and as community members, it is our responsibility to raise awareness, especially on not just the conversations that we're having to clarify on some of the misconceptions, but to also educate one another about the pertinent areas that we are primarily missing. We do also encourage that communities do extend invitations to organizations like Lawyers for Human Rights, Save the Children, which is also part of the South Africa, and other organizations that we've partnered with, like ACT Africa, and as well as AIHLI Legacy, to elaborate further on some of these subjective thematic areas where there's great misunderstanding or misconceptions and stigmas associated with people or persons that are falling within the vulnerable groups of individuals that are not documented or have documentation but have it blocked, and how that fundamentally really affects an individual. And so it is now between ourselves, as we have these conversations, that we lead them further beyond just virtual engagements to having in-person and frank conversations amongst ourselves as community members about these pertinent issues. So thank you very much, Thandeka. Your work speaks for itself, and we continuously will be not just following your efforts and the works that is done through the Lawyers for Human Rights, but will continue to share and as well as shed light on some of the advocacy work that you guys are doing at all times.